I'd like to welcome everybody and to thank you for being here in support of this event today and for the scholarship that's being named in honor of Judge Stanley Sporkin. I think everybody here knows that Stanley was widely recognized and is remembered as a remarkable public servant. I think he was a unique, combination of integrity, dedication, intelligence, and creativity. And he was also, to many of us, a fantastic boss, mentor, and friend through the years. He was truly one of the most remarkable people I think I've ever known. As director of the Division of Enforcement, Stanley developed and led what I think we consider to be the most admired and emulated enforcement program in all of government. And the Sporkin area, as it's often been known, is also known as the golden era of enforcement from an SEC perspective. And today, the enforcement panel is going to be focused on some of the most creative and pragmatic programs and initiatives that were birthed by Stanley during his time at the commission, and bring them forward to talk about their relevance and importance to both the commission and other government agencies today. And we look forward to that. I'd like to recognize that all three of Stanley's children will be here this morning, which we're very honored to have you. And I'd like to introduce two of them who are sitting here in the front row, Liz Sporkin to my left and Dan Sporkin, both of whom Stanley used to talk about all the time to us. And their brother Tom should be here shortly. So thank you all for being here, and we appreciate it. And with that, what I'd like to do is to introduce the current president of ASECA, Anne Marie Tierney, who will make a few remarks, and thank you.
Hi, everybody. First, I'd like to welcome you all, add my thanks to John's. I'd like to specifically thank John for all the incredible hard work that went into this event and for getting such amazing speakers for our inaugural panel. We're all very proud to be part of the SEC family. I particularly was not in enforcement, so I hope you'll bear with me as a former court finner, but I very much respected everything that Judge Sporkin brought to everything that he touched. And so again, we're really, really proud that we're able to endow the scholarship today. We want to thank all of our sponsors for their extraordinarily generous contributions that let us start with a fully endowed scholarship as of today. So congratulations to all of our sponsors for helping us get to that point. And I'd like to bring up Susan Markle, who's the chairman of the Society of SEC Historical Society, to also welcome you. They are co-sponsors of our event.
Thank you, Anne, and we appreciate the opportunity to co-sponsor this event. As Anne said, I'm Susan Markle. I'm chairman of the SEC Historical Society this year. I've been associated with that organization for many years. I'm also a partner and managing director at Alex Partners here in DC. The SEC Historical Society is a nonprofit charitable organization which preserves the history of the SEC through its virtual museum of financial regulation. It's a tremendous resource that tells the story of how the SEC regulates the capital markets. It also provides a home to memorialize special events such as this one. The Society is unique because we are also an independent, nonpartisan organization separate from the SEC. We're delighted to exhibit today's panel discussion in the Virtue Museum, probably later this month, which will be alongside Judge Sporkin's other materials. Time doesn't allow us to show it, or else we'd have some of the things flashing behind us. But you'll see if you go to the museum, oral history, speeches, photos, letters, and there's other programs about Judge Sporkin's career and legacy available at sechistorical.com. And all that information is free to the public, as we are a nonprofit charitable organization. If you have additional questions about the Historical Society, feel free to approach me. Kathleen Graham is our new executive director. Jim Barrett is our past chairman. And again, look forward to this great presentation, and thank you to ASECA for inviting us to co-sponsor.
Thank you so much. And with this, I'll reintroduce John Hartigan, who will introduce our panelists. Thank you again.
Before we start the program, I'd first like to introduce Dean Jean Finn from Georgetown, and to recognize and thank Georgetown for their assistance with this program. Georgetown is donating their time, their space, sponsoring the cocktail party, and generally doing everything they can to support us, both with respect to this inaugural event and to hosting it on an annual basis in the future, as well as to, assisting us with the launch of the scholarship, which will basically fund internships by students who are interested in the Division of Enforcement, whether it's from an intern standpoint or working there in the future. So something Stanley would have loved, and we've been able to put it together with the assistance of Georgetown. And Jean, if you'd like to say something, and particularly talk about why we're here today, because unfortunately either a beam cracked or a cable snapped and the ceiling is now sagging in the Hart Auditorium. And for some reason, Jean was a little concerned about liability.
Yeah.
So they maneuvered quickly. Why a law school dean would care about that, I don't know.
We were checking with all of our faculty that are experts in that area, and they said, don't have it there, needless to say. First of all, I'd like to thank John. For those of you who know John, when he calls you and asks a favor, it's very hard to say no. So we were very, very pleased to be able to host this today, and it was a real pleasure working with John. What he was talking about was the venue change at the last minute. We were supposed to be in a brand new auditorium, Hart Auditorium, absolutely beautiful. Next year, we'll have the program there, but there was a last minute problem with a cable snapping and a very serious safety issue, so I apologize for that. The nice thing is you're only a few steps from the reception afterwards, so that makes it easier. I do want to stress how proud Georgetown Law is to have this scholarship being housed here, to have Judge Sporkin's name associated with an endowed scholarship is very, very important to us. You should understand that as an endowed fund, that means every year in perpetuity going forward, a student is going to receive a scholarship in his name. And what we do in my office is we make sure the students receive a little bio on whomever the scholarship is named for. So all of his great work over the years will be remembered each time the scholarship is awarded. So I think for those of you who have worked with him, there will be that legacy. So we're very, very proud of that. So please enjoy the panel, and thank you for coming. Appreciate it.
Now I want to introduce one speaker who started at the SEC in 1977 and worked for Stanley. From there, at one point in time in his career, when Stanley was appointed as a federal district court judge, he had the honor of being Stanley's first law clerk. And subsequently, he's been a partner at McDermott, Will & Emery. And I'd just like to recognize the fact also that in Stanley's final year or years, Jean made it a point to visit Stanley weekly, and not just to spend time with Stanley, but also, they had the benefit of hearing so many of the war stories and reminiscences. And, trust me, from what I understand, there was never a repetition, and there was always more food for thought. And Jean hopefully will share with us some of his remembrances of Stanley and his perspective. Jean.
John, thank you. I'm very honored to be included in this tribute to a true patriot to his country. And I know the Sporkin family is touched by all the work that has got into this program and the scholarship. While Stan's incredible career and legacy are the focus for today's panel, such a discussion would be incomplete without remembering Stan the person, his true friendship, someone willing to help so many others with their careers and personal problems, someone who stayed in our lives well beyond the time we worked for or against him. Officiating at our weddings, being the best man, making that phone call or letter recommendation to help advance careers. He was there for Bill McLucas and other directors for guidance and support on how they were going to run the division. He learned being a mentor from having a great one of his own, his beloved predecessor and SEC Commissioner Irv Pollack. Stan further showed his generosity by picking up the tab at the annual dinners for his former clerks and their families. His point in doing so was not just to furnish delicious deli sandwiches to his clerks, along with chicken in the pot. He wanted the clerks' families to get to know each other. Stan could have cashed out decades ago, but he did not, in order to serve the public good. Most importantly, Stan taught us what is right and just. As Joel Seligman wrote in his brilliant tome on the history of the SEC, The Transformation of Wall Street, quote, "No history of the SEC would be complete without noting the competence and ingenuity of Stanley Sporkin. We realized while working at the division under Stanley that no matter how important, how powerful the person was or the firm was that was under investigation, whether it was President Carter's friend and OMB Director Burt Lance, George Steinbrenner, William F. Buckley, Charles Blumenhorn and Gulf and Western, Meshuam Riklis, Robert Vesco, and many others, if there was alleged wrongdoing, they would be held to account, but in a fair way, with the investing public learning the facts." I say in a fair way, and I'm sure Bill remembers this. There were times after long investigation that some of us would hold our breath at meetings between Stanley and Defense Counsel. We were worried that Stanley might agree to drop Sienter-based charges. His message to us was that we had to treat people decently. And what was important when there were mitigating factors was that the facts came out and the company cleaned up its act. It says much about Stanley's reputation, toughness, his reputation for toughness and fairness, that the most aggressive pillars of the defense bar and public advocates such as Ralph Nader praised him at the same time. There's no doubt that Stan caused the enactment of the FCPA. The State Department opposed Stanley's efforts to pursue companies for foreign bribery. Stan disagreed with that. He believed that the bribery of foreign officials by U.S. public companies damaged investor confidence in our corporate institutions, that it made no sense to have the purchase of goods and services depend on whether there was a particular minister or cabinet person in a foreign country in place at the time to accept the bribes. He believed it was material, undisclosed risk to shareholders that big orders, construction contracts, and military sales depended on bribery instead of the quality of the goods and services. It is well known that Stan knew something was amiss from watching the televised Watergate hearings and the revelations of publicly traded corporations made off-book secret contributions to the campaign to re-elect President Nixon. We can envision Stanley's mindset as an accountant. How are black bags of cash that belong to the shareholders being accounted for on the books and records of the company? The SEC was granted access to the records of the Watergate Special Counsel, and Stanley was off to the races. What followed was a voluntary disclosure program, a topic for the panel, and the rest is history, with continued robust FCPA enforcement by the SEC and Department of Justice. Now, when we talk about Stanley as a person, I'd like to add a word about the affinity between Stanley and Commissioner John Evans. Two people with completely different backgrounds. Evans, a devout Mormon from Utah, came to Washington to serve as a Republican staff member on the banking committee under the original Senator Wallace Bennett of Utah. He was appointed by President Nixon. As a conservative, he believed, as Stanley did, that robust disclosures and strong enforcement against corporate corruption are necessary to foster confidence in the capital markets, that fixed-rate commissions among broker-dealers prevented true competition in the investor marketplace and had to be eliminated, and they were. What a beautiful thing to see, have a soft-spoken, mild-mannered economist from a small town in Utah work together with the not-too-shy son of a Philadelphia judge. Sometimes Stan's law clerks are asked whether they detected whether Stanley carried over lessons from his SEC days to the bench. There was a case I'd like to share with you. A mentally disabled young person was walking down the street in the District of Columbia. He saw a policeman chasing him. So his normal reaction was to run. And he was beaten. And he was taken to the hospital. And fortunately, his family was able to get in touch with one of the advocacy groups, and they gave him good counsel, and they brought a case, and it was before Stanley. Before Stanley, you have the medical records. No question, the child was beaten. Who was responsible? Well, the Washington Metropolitan Police were blaming the Capitol Police. The Capitol Police were blaming the National Park Police. What they had was one digit of the policeman's badge number, but they couldn't find out who it was based on one digit. So, a little bit of audience participation. Guess what Stanley did from the bench? Any guesses? He ordered an internal investigation to be done by the police department. They objected and said, Your Honor, we don't think you have the authority to order the police department to conduct an internal investigation. He says, yes, I do. They did. They found the policeman, and justice was done. Thank you very much.
So it's my pleasure to introduce the SEC Enforcement Panel. I'd ask the speakers to please come up. So it's my pleasure to introduce the speakers. To my immediate right is Bill McLucas, who started the commission in 1977 and had the distinction of being a fellow Penn State alum with Stanley Sporkin. And despite that, they grew very close over the years. And I think Stanley would be very proud and honored to have Bill moderating this first panel being named after him. To Bill's right is his partner at WilmerHale, Stephanie Avakian, who was director and co-director from 2016 to 2020. To her right is Steve Peikin, who is a partner at Sullivan and Cromwell, was director from 2017 to 2020. Immediately to their right is Andrew Ceresney, who's a partner at Debevoise and Plimpton, who was there from 2013 to 2016. And on the far right, last but not least, is Gurbir Grewal, who is our current Director of Enforcement, and we very much appreciate all of your being here. So Bill, with that, I will leave the podium to you.
Thank you, John, and thank you, Gene. We had hoped to have an event like this several years ago, but as you know, COVID intervened and we had to postpone things. But finally, here we are, and thanks to the Alumni Association and to the Historical Society for sponsoring it, and to Georgetown. This is a great event. Personally, it's very special to me, and I know it is for the other directors of enforcement who are here and the alumni of the Enforcement Division. To set the stage for what we're going to talk about, I wanted to initially spend a few minutes taking us back to the 1970s. Unfortunately, for most people in the audience, that sounds like I'm talking to my kids in World War II. But there are a few of us that are old enough that we might remember the 1970s, the hair, the wardrobes, and a few other things. And hopefully I can add a little bit of color to what it was like to be at the SEC during that period of time. Then we're going to turn to my colleagues on the panel, and we're going to talk about what aspects of the program of Stanley Sporkin's legacy remain today as critical components and core aspects of the way the division operates and of the program. And that would include everything from SEC settlements and the neither admit nor deny issue, which comes under assault periodically. It's like Haley's Comet on a much shorter fuse. The agency gets criticized for not demanding admissions. the notion of pursuing gatekeepers, lawyers, underwriters, accountants, the reliance on boards, board committees, and independent investigations to do the work that the government wouldn't have to do to clean up issues in public companies, the independence of the SEC and its enforcement and investigatory activities, and how that remains a core issue within the agency and within the division. And then we'll talk maybe about the SEC's increased use of the administrative process, the use of penalties, which, remember, during the Sporkin era were non-existent. There were no penalties. You didn't get your pound of flesh in dollars and cents. You got it in public opprobrium and in what could be set forth in the contours of a complaint. And finally, maybe we'll talk about cooperation a little bit. But first, again, I would like to talk about the SEC and the enforcement program in the 1970s. As you know, Stanley was the second director of enforcement. There was no separate division of enforcement until 1972. All enforcement was done out of trading and markets. And in 1972, Irv Pollack was named the first director of the division, and 2 years later, Stanley Sporkin was elevated to be the director of the division, and Irv became a commissioner. Stanley served until 1981. The environment back then, the SEC was located at 500 North Capitol Street, which is about 2 blocks from where we are right now. And this area, the space 50 yards to my right, was a parking lot, which when you were going to work, if you were able to get there by 8:30, the fee was $1.75. If you missed that, I think it was $2 or $3 for the day. And 500 North Capitol today looks like quite an inviting building and a nice place. The dean mentioned a few minutes ago that there was a structural issue in the auditorium, and the beam was sagging and the ceiling might fall. Hell, we'd have been comfortable over there back then because the facility at 500 North Capitol, politely speaking, was a mess. There were boxes that lined the halls, many of them dust-covered, boxes of files, open cases, closed cases. If you were an enterprising reporter and went down the hall with a notepad and could read quickly, you could figure out which companies were under investigation. Some of them would have been closed, some of them would have been open, but it was all there. It was all in the halls. The only person that could have shut down the SEC in the 1970s was the fire marshal, because it literally would not have passed any sort of inspection or critical examination for being a fire hazard. Smoking was permitted in the building. Cigars were favored by quite a few people, most prominently Ed Hurley of Wachtell Lipton, now of PGA fame. It sounds remarkable, but that was the reality. Stan's assistant was a lovely person named Betty Davis. And Betty maintained, just outside Stanley's office, a hook that had been taken from a butcher's office, and it had numbers on it. And on a busy day, when you wanted a meeting with Stanley, you took a number. And you waited. And it was interesting to see defense counsel come in and out of the building because there was no budget for a hospitality suite. They would mill around in the front office area uncomfortably, trying to find a space to unobtrusively look like they weren't there to plead, either to end a case or to settle a case, and usually trying to avoid snagging their suits on the metal cabinets and the desks that were in the area because there was no room. Now, let me say a word or two about the leadership in the division under Stanley. The division had what I would politely characterize as a lot of character and an enormous number of characters. Those few from that era, and I'm looking around, and unfortunately, I probably am the oldest guy in the place except for John and perhaps Gene, who might remember some of these people, but the Names some of you would recall: Mike Schulman, Erwin Borowski, Wally Timoney, Lester Green, Ira Pierce, Ben Greenspoon. This was quite a collection of extraordinarily brilliant and talented lawyers and extraordinarily eccentric people. They were idiosyncratic, but they were dedicated, they were tough, and they were wonderful people. And they were extremely, extremely loyal to Stanley and to the mission of the division. Now remember, again, most of us will remember, I guess the younger folks won't, no email, no iPhones, no text messages. It was all paper. We had 2 copy machines on the floor, and I think 1, maybe 2 fax machines, but everything was done in a fashion which today looks like it was horse and buggy, but it got done. The outside world's view of the SEC was considerably different from what we maintained within the building. To the corporate world, to Wall Street, to the financial services community, Stanley Sporkin was the enemy. He was both feared and loathed by corporate America. If you go back and were to read articles from the 70s, and we'll get to the foreign payments or the voluntary disclosure program in a minute, you would get the flavor that the press was so enamored with the mission and the initiatives that were being undertaken at the SEC, and the private sector was bitterly, bitterly opposed to the enforcement initiatives that were undertaken under Stanley Sporkin. Now, within the division, and to some degree within the agency at large, Stanley Sporkin was loved. He was creative, he was fearless, he was demanding, and he was passionate. And he had what I would call the it, whatever it is that makes a great leader. And we've all, at some point in our lives, experienced working for someone who has that thing. And what he had was an ability to inspire people, to get you to do the extra 10 hours a week, to go the extra mile, to worry through getting it right. And he had it in a way that all of us, I think, have worked for people or experienced people at some point in our lives that have that. He had it perhaps more than anyone I've ever worked for and known on a personal level. The morale in the division at the time was at an all-time high. I don't think there was another agency in the federal government that came close to the morale within the SEC and within the Division of Enforcement. Stanley embodied what I would characterize as the SEC spirit of independence, integrity, and can-do mentality. So since then, we've had 12 people who've occupied the position and held the title of Director of the Division of Enforcement, and 4 of my colleagues are here today. I think every one of us aspires to do the job, have the public commitment, and get out of the staff and the agency what Stanley got out of the division when he was the director. And it's interesting, you almost cannot mention Stanley Sporkin without saying the name of Irv Pollock. And that's a tribute to Stanley, because I don't think there was ever a conversation I had with him about the division and his tenure when he didn't talk about Irv as his mentor and Irv as the model of what a public servant ought to be. Now, I want to talk for a few minutes about the program in the 1970s under Stanley Sporkin. Like today, the division was focused on a broad range of different issues: accounting, full disclosure by public companies. There were sales practice cases. There were cases against the securities industry and investment companies. But back then as well, Stanley pioneered the efforts that the SEC made into addressing abuses in connection with the issuance of municipal securities. In 1977, the SEC issued a landmark report called In the Matter of the Finances of New York City, which basically disclosed that the city was selling municipal tax-exempt securities without disclosing that, in effect, the city was bankrupt. That investigation paralleled an investigation involving the city of Philadelphia. And those cases were fought bitterly by the municipal governments involved, alleging the SEC had no jurisdiction to engage in any such investigation. It sounds familiar, I think, to the four people to my right, depending upon the issue or the initiative that the divisions embarked on. The commission also brought cases involving perquisites, the Playboy case. They brought cases involving affiliated transactions and self-dealing. One of the more famous was against Star Broadcasting, which was a company that was controlled by William F. Buckley, then the most prominent conservative voice in America. To say that the division stepped on toes of important people is an understatement, and it didn't matter your political persuasion or identity. Same thing with the case against the National Bank of Georgia, which implicated the then director of the Office of Management and Budget, Burt Lance, who was President Carter's, one of President Carter's closest friends. Now, a side story that followed on that case is that the following year, Stanley was awarded the Presidential Award for Distinguished Service. Unlike most presidential award recipients, he wasn't invited to the White House. Now, no one ever said anything about this, but the notion that it had nothing to do with the Burt Lance case is probably not accurate, but in any event. Of course, the most prominent aspect or feature of the enforcement program in the 1970s was the voluntary disclosure program. And Gene alluded to it, and I want to say a few words about it because it was the highlight of the SEC's initiatives during the 70s. The program emerged basically from Stanley sitting at home and listening to the Watergate hearings. And the Watergate hearings, as many of you know, were all about what came out was the fact that in the committee to reelect the president, which was run by John Mitchell, the former Attorney General, and Maurice Stans, the former Secretary of Commerce, bags of money, literally paper bags and in some instances briefcases of cash, were being delivered to the committee to reelect the president. And Stanley was listening to the hearings, and he basically was thinking, how can this happen? And where on the books and records of the public companies, because many of the public companies were delivering the money, where's that money being reflected? How's it being accounted for? And where are the auditors? How can this possibly be happening? So the division opened a number of investigations that were directed at companies that had been identified in the hearings. And the focus was off-the-books accounts, slush funds, and then domestic or foreign payments for political or business purposes when dealing basically with bribery or efforts largely in foreign markets to get business. And these investigations, as you can imagine, were met with pretty ferocious resistance. The arguments by the public companies were that the inquiries were directed at matters that were immaterial. And they therefore ought to be stopped in their tracks because these are beyond what any investor would consider reasonable. Whatever amounts of money are involved don't matter to the company's financial statements. The SEC's response basically was, first, we need the facts before we get to the materiality issue. But secondly, this is where the integrity of management theory was born. If leadership of a public company can deliver bags or briefcases full of cash for business or for political favor. What about management of the company? What does that say about them? Or the directors of the company who oversee management of the company? Are they aware of it? Is this something that's legitimate? In any event, Stanley and Alan Levinson, who was then the director of the Division of Corporation Finance and who was another one of the giants of the SEC bar when he left the SEC and went to Fulbright and Jaworski, got together and came up with the idea of having a formally announced commission program. And that program was to say to public companies, come in, lay it all out and fess up. And if you do, it'll be taken into account when we decide what, if anything, to do. If you don't, and we open an inquiry and we get the facts, you get no credit and you'll get the harshest reaction we possibly can. The program didn't guarantee immunity, but it was sufficiently concerning that companies began to fess up. Now remember, this was really at the time a revolutionary idea. Corporate America was on a warpath to restrain the SEC and to deal with this guy Sporkin. He was embarking on something that threatened, in the view of corporate America, legitimate corporate behavior to advance their interests and the interests of the shareholders. But there were a number of significant things that could not be easily dismissed. The first is the revelations at the Watergate hearings, and eventually through the disclosure program, with hundreds of companies coming forward, turned the public perception of what was going on in a fashion in which resisting the SEC's initiative and efforts was not going to be feasible, because it was viewed as scandalous that cash would be delivered in paper bags the way it was happening with CREEP. And the second thing is there was a very powerful SEC ally on Capitol Hill, and that was Senator Bill Proxmire on the Senate Banking Committee. And Proxmire used to give out what was called the Golden Fleece Award. He would identify public servants in the government who squandered money and who were engaged in wasteful behavior. He was basically a populist and a crusader, and he was fully supportive of the SEC's initiative and the whole foreign payments program. And these developments contributed to the ability of Stanley and the SEC to maintain the moral high ground to continue with the program. Once the program began, over 400 companies made voluntary disclosure of off-the-books accounts, slush funds, and inappropriate domestic and foreign payments. And that revelation led to the passage on December 7th of 1977, the Foreign Corrupt Practices Act. That program in that era spoke to Stanley's genius. What he accomplished, I don't know if it would have been done without somebody with his character, his personality, and his drive, and his doggedness. The press at the time really lionized Stanley and his efforts, but there was an undercurrent of anger and an undercurrent of forces who wanted Stanley out and wanted the program stopped. And it's for another program or discussion, I suppose, but eventually that is what happened after the election in 1980. Stanley resigned as the director of enforcement and went over to the CIA with Bill Casey, who had been the chairman of the SEC earlier in Stanley's tenure. One little story I do want to mention about Bill Casey and Stanley. During the investigation into illicit payments, Stanley had issued a subpoena for a company called iOS, which was run by a guy named Robert Vesco. Vesco was an infamous crook who had stolen over $200 million of investor assets, and $200 million then was a lot of money. And he became a fugitive, and Stanley and the division had subpoenaed Vesco's executive assistant. Vesco had made a substantial contribution to the committee to reelect the president, cash contribution. And the White House reached out to Bill Casey and said, you know, your enforcement division has an investigation. It would be nice if they could cancel or at least postpone the testimony of this executive assistant. Bill Casey called Stanley and said, I got this call from the White House. They want me to postpone this testimony. Stanley said, no, can't do it. And I think Casey said, well, if it's just postponing it, Stanley said, Bill, we're not postponing the testimony. If you want to postpone it, get yourself a new director of enforcement. Bill Casey called the White House and said, sorry, we can't reschedule. And at the time, Stanley said to Casey, you will thank me someday for this. And of course, in the Watergate hearings, Bill Casey testified under oath about this call, the conversation with Stanley, and the resistance to White House interference in the SEC investigations. And, you know, that's a story Stanley has told many times over the years. There would always be a nuance or a fact or a twist that might be a little different, but the core of the story was basically the same, and it was true. And the advantage I think I have of speaking about all this today is that, A, the statute of limitations has expired, and hell, none of you would remember whether I'm right or wrong anyway. So I thought now we ought to turn to the panel and talk about some of the aspects of the SEC's program that really found their genesis in the Sporkin era. And one of them is the notion of settling and neither admitting nor denying. And as I said, periodically, there are a bunch of critics of the SEC who say, this is outrageous, you're letting these people off the hook. But the SEC, generally speaking, has held firm to that approach to settlements. And I'd like to open it up and ask anybody on the panel to start, and if you don't, I'll pick someone. Where are we on that now? Does it still work? Do you get a lot of pressure over it? And do you think it still makes sense?
So
Feels like you.
I'll just give the disclaimer that my views are my own in my capacity as the division director, don't reflect the views of the commission, commissioners, or the staff. Where we are is in litigation. Where we are is in the Fifth Circuit with no admit, no deny under challenge. It's been under challenge in other courts. It's been under challenge by litigants, most famously Mr. Musk, who Steph and Steve had the pleasure of dealing with, and I now have the pleasure of dealing with, trying to get out from some of his settlements in the Southern District. So it's under challenge. It's an important part of the program. I don't think we're able to move forward at the pace we want to move forward if we don't have no admit, no deny. And so we're fighting to preserve that tool, and it's voluntary. It is agreed to by the parties. It's in the best interest of parties who want to resolve a matter, and there are cases where we do seek admissions, and Andrew laid out the policy around those cases, and we continue to follow that policy, and in a certain amount of cases seek admissions. So to be continued.
Andrew.
You're like, let me turn to the guy who was at the commission when we decided to change the policy a little bit. Actually, I should say first, Rob Kuzami, who's here today, prior to me becoming director, my predecessor, was the first kind of kink in the armor where the decision was made that if you admitted to a criminal or other resolution that you could not do a no admit and deny settlement. So it was basically like a no deny settlement. And that was the first sort of movement. And then when I was director and Mary Jo White was the chair, we decided to implement a policy of requiring admissions in certain cases. Now that was, there was a lot of pressure at the time to actually go further. There were people who said we should do no admit, no deny settlements. And I think we all recognize that wasn't a practical option. You have cases that are brought, first of all, you have cases where there are criminal components and if somebody admits to violations, they're basically admitting to a crime, insider trading and the like. That was never going to be something you could get an admission to. Also, there were collateral consequences that companies weren't going to accept if they admitted to essentially, particularly if there was a class action pending or something else. So those were always, and then there was also like the proof issues, right? In cases you didn't have. You often were bringing cases where you didn't exactly have the goods, or you didn't have enough goods.
Really?
Yeah, you had enough goods to believe that an act.
Taped? Can we get?
Yeah. Okay, so now we're going to tell the truth about all SEC settlements, right? Not every SEC settlement is a case that is built upon evidence beyond a reasonable doubt, and sometimes it's 51-49. You think you could win it, but you're taking a chance, and you eliminate risk by doing a no admit, no deny settlement. So we had to have sort of a bit of a flexible policy. But I actually believe we got over 80 admissions, and I think there was sort of a combination of cases where it was a meaningful remedy. It was sort of, I viewed it as sort of an additional tool in the toolkit. And I think it was effective in lots of cases as an additional remedy. The first one we did was Phil Falcone. That sort of made a big splash because he did admit to 10b-5 violations. And there was, I thought that was important. And we had other cases where it did send a message, particularly in cases like, for example, where people were going to be witnesses, and we wanted to lock in their testimony and the like, and that was important. So I think I'll tell one story about Judge Sporkin, Stanley, I guess as he told me I should call him. So when I was obviously when I became director, one of the things I did was reach out to others who had preceded me, Rob, Bill, and others, and I reached out to Judge Sporkin, and we had a discussion, and he gave me his thoughts. One thing I will say is it was very funny. I do distinctly remember that he was not a big supporter of penalties, big penalties. What are going on with these penalties? Why are you guys extracting these huge penalties? I'm sure we'll get to that. And it wasn't something that he thought was necessary at the time. He thought we were going too far. I explained to him times have changed. He didn't quite accept that, and I didn't change his views. But when it came to admissions, he actually was not a fan of it, as I recall. And I recall discussions with him where he was like, what are you doing? And, we had a discussion about it, and I explained times have changed and that, there's a different atmosphere. I'm sure one of the things we'll talk about was some of the changes in the world of being director of enforcement now than it was then. But so he wasn't a supporter of it. But I think, ultimately we tried to do it in a measured way. People will judge someday whether we succeeded and whether, the approach will continue. But I think ultimately, at the end of the day, obviously the vast majority of settlements are still no admit, no deny. So,
Stephanie, Steve, yeah.
I'll tell one Stanley Sporkin story, which was at an event here, I think shortly after Stephanie and I became co-directors. Someone brought us up and introduced us to Judge Sporkin, and he looked at us, he said, "Why are there two of you?" And I said, the only polite thing I could say is, "That's funny, we've both asked the same question." On the question of admissions, shortly after I came on board, I was speaking at the Securities Enforcement Forum conference, and I made stupidly some derisive comments about the importance of seeking admissions. And the next day, Dave Michaels wrote an article in the Wall Street Journal. The headline was, "SEC abandons prosecutorial approach to enforcement," which is not exactly the headline I was looking for. So I think, so I'll be measured in my comments about admissions.
You don't have to now.
Yeah, exactly.
You don't have to now.
I think, look, my view was we got admissions in a number of cases. I think it boils down to, were we ever going to litigate a case just over the question of admissions? I didn't think so. Others might, make that policy judgment differently, but I think our view was, if you get all the remedies and relief, including perhaps, disgorgement that would be returned to investors, or you could litigate for 3 to 4 years before getting that in the hopes of getting admissions. Is there any case where that game was worth that candle? And I think, we answered that, in the negative. I don't think we ever were forced with that choice, but I think philosophically that was kind of our view.
Just
Yeah,
a
no.
comment. You guys sound so much more reasonable now than you did when.
Well, I know we got admissions from you.
Stephanie.
No, I completely echo what Steve said. We really did sit back and think about, what are the things we're going to fight over? What are the things we care the most about? And I think, there were a handful of cases where we got admissions. I think for the most part, you can look at them and see why they were important programmatically, or the facts were important to sort of be out there in the marketplace. But we didn't, look, we put a real priority on resource allocation and on wrapping up cases and getting the relief we needed to get as quickly as possible. And I think this was one of the areas where, for the most part, I think we didn't see a huge value in, as Steve said, being prepared to litigate over this issue.
I guess one of the things I will say is that there were a couple of cases where we did end up litigating over admissions, because one of the most important things was that you didn't,
Right.
if you asked for admissions, you made an assessment that you were going to ask for them, and if you asked for them, that you couldn't back off. And that was important just for the integrity of asking for the remedy. So there were a
So
couple of
Rob,
cases.
he took neither your advice nor my advice.
I don't know, yeah.
Let's switch for a minute and talk about gatekeepers, underwriters, accountants, and lawyers. And Stanley's famous quote in the Keating case, which is, "Where were the lawyers?" But it goes beyond that, because it really was focused on anybody that really held the keys to access to the public money. And I'd start with you, Gurbir, and talk about where the program is now in looking at that. And obviously with lawyers, it's a very, very hot button issue, not just with many of us, but generally speaking, and how you approach the question, do you go after lawyers? Good idea, bad idea?
Yeah, obviously I didn't have the good fortune of speaking to Judge Sporkin or having met him before, but in preparation for today, reading his past remarks about the Access program, hearing from you in preparation for this panel, I don't think there's much space between where he was on gatekeepers and where any of us have been, because I think all of us have spoken at different times about the importance of gatekeeper accountability, whether it's where were the lawyers, where were the accountants, where were the people who were supposed to make sure that people were playing within the chalk lines. And so we continue to place an emphasis on holding gatekeepers accountable when the facts support that accountability. With lawyers, it's a difficult call, and it really is. We don't want to chill the conversations that happen between lawyers and their clients. We want that conversation to happen, and hopefully that consultation leads to the right result. But we also don't want people to hide behind vague assertions of presence of counsel or vague assertions of lawyers being in the room. And so we will push those issues, whether it's an assertion of privilege that you're truly making or not. And if lawyers are involved in the wrongdoing, that's a whole different story. We're not talking about seeking advice from lawyers. We're bringing cases and have brought cases where the lawyers were part and parcel, of the fraud. I mean, they were knee deep in it. So I don't think whether it's accountants, lawyers, compliance professionals, other gatekeepers, that any of us have been in different places. And I think all of us have spoken at various times about, for example, CCO liability. I gave a speech and you would have thought I broke new ground, but I cited Andrew in the footnotes, and I laid out the principles, that we would apply when we're seeking to hold compliance professionals accountable, whether they were involved in the fraud, whether there was a wholesale breakdown in the compliance function, whether they ignored, obvious red flags. And if you look at all the citations, they're to a speech that he had given maybe, 5 or 6 years before then. And so I think these are issues that find their root back in Judge Sporkin's time, that you can't be everywhere at once, but so you want to look at the folks who have access and bring accountability in that manner. And, we're in the same place today.
I think that's right. I agree with Gurbir that I think we've all sort of looked at it the same over time. I think where you see the ebbs and flows over time, particularly with CCOs and lawyers, are the occasional forays, I think that, that the public and the community, the legal community start to think go too far, right? Where you're putting obligations through your investigation, putting obligations on the CCO that don't belong on the CCO. Maybe they belong on the business, maybe they belong elsewhere, where you are questioning a lawyer's advice. They gave the wrong advice, but maybe they negligently gave. I mean, people get it wrong sometimes. And I think we've seen this over the years throughout all of our tenures. I think we've seen those cases and those investigations that delve into those areas and call into question where the boundaries are, particularly for CCOs and lawyer liability. And I think that's going to continue to be a question. But, Giovanni gave that speech all those years ago. And I think what he said, ought to continue to hold true today. It certainly did through our tenure, which really is, as Gurbir said, the investigations of lawyers should really be when the lawyer's part of the problem, when the lawyer's part of the conduct, but not really getting into, okay, they gave some bad advice, or they gave some advice I don't like or I wouldn't have given. And so I think this is an area where we've seen a continued focus over time. I think we'll always see a focus from the commission on it, but I do think we've all had to be careful and we've all had to keep an eye on those issues, and I think that'll continue to be the case.
And I think, I'm sorry, Steve, go ahead.
No, I was just going to say, echo one of the things you said, which is one of the things that irritated me was the sort of presence of counsel defense.
Yeah.
Most of the things that the Enforcement Division investigates involve fairly sophisticated transactions in which lawyers are involved. And the fact that a lawyer was around, to me, signified nothing. And I found it, frankly, a little bit insulting to think that we would be backed off by virtue of this incantation without a waiver, without any real delving into the core of the advice. If there was that, of course, I think that, could be a very substantial, mitigant to a finding of scienter or even negligence.
And I think the message, though, when you do bring gatekeeper cases, it resonates, right? We've brought a handful over the last fiscal year, Prager Metis around auditor independence issues, the Markham case, which some of us on this dais are familiar with, where Markham was, the accountant for, I don't know what percentage of the SPAC space. And, I thought that sent an important message, and there's individual accountability flowing from those cases. And another case that sort of ties together gatekeepers, ties together penalties, ties together admissions, I think was our EY case, the cheating case, which some of us on this dais are familiar with on the other side.
Are you just going to mention cases I was involved in? Is that what you're going to do here?
No, but
Dude, that was just a copycat case of our KPMG case.
well, exactly.
He could have just said the case, but he said the cheating case.
No, but when you have gatekeepers at the gatekeeper cheating on, of all things, the CPA, the ethics portion of the CPA exam, and it's not the first case in the space, it's on the heels of KPMG, which Steph and Steve brought, I think at that point you require admissions because you need to send a message of accountability. At that point, you require a bigger penalty because you need to send that deterrent message. And that's what we did in that particular case. So you have a gatekeeper, you've got big penalties, I think it was $100+ million, and then you have admissions. And so I think to wrap it all up in one, those are important cases.
Rob, we're starting to sound reasonable when you and I were there.
Can I just make one point, Bill? I'm not going to talk about those cases, but I guess the one thing I would add on this is that the concept of gatekeepers, I think one difference over time has been the expansion of the types of gatekeepers. Yeah. Like, I think we've sort of viewed it now, from ATS cases that we brought when I was there, or credit rating agencies or the like the definitions of gatekeepers have really expanded, and I think that's part of the innovation there.
So let me ask each of you about the idea of one of the aspects of the voluntary disclosure payment was there had to be credibility behind the disclosure. Who did the review? Was it complete? Is it reliable? What about now this notion of independent investigation, special committees, audit committees? How do you look at credibility? Is this enough? Are we going to go redo the whole investigation, kick the tires? What goes into the judgment about how the staff reacts to a company coming in and saying, well, we've got this committee, we've got the board, they've looked at us, we've got these lawyers, here's the report, that's it. How do you assess that?
I mean, I think it really depends on the credibility of the lawyers coming in. And it really depends on whether it's a select committee or it's a law firm reporting to an audit committee or an independent committee, and you know, that there's a robust back and forth during the investigative process where, you know, we're getting updates on what's happening during the course of the investigation, where we're able to give feedback, where there's that sort of relationship that develops, as opposed to, I think, you know, those internal investigations, to be candid, that are just whitewashes, right? That where you're just going through the motions and not having that interaction, or may not be truly independent. And so I think it's those types of factors that would move us, you know, either to wait on the results before making a decision, or to, you know, move forward with our own investigation and not, you know, wait the outcome of that investigation.
And you, the rest of the panel, how do you decide what to tell the client? Good thing, bad thing? Because there are pros and cons of doing these independent investigations, because one of the cons is, if, you know, not to be too blunt about it, but if you don't want to know, don't ask. And if you're going to do it, you got to do it. And it's got to be by the book, and it's got to be credible. But when you begin these things, I think clients initially think, oh, good Lord, thank God. We don't have to deal with the government, we'll deal with the lawyers. But that means, you know, if you're going to deal with the lawyers, it's going to be a fairly thorough review and report.
Yeah, I mean, I think, you know, you can't say this for all cases, but, you know, developing a strategy based on the presumption that the government's never going to figure this out is a loser's game. And, you know, there are cases, obviously, where the government doesn't have the resources or the wherewithal to actually find things out, but making that the core of your strategy is a short-term game. And I think if you had a choice of, you know, I mean, the enforcement division can destroy you just by wearing you out forever. And, you know, personnel is policy. And if you draw the wrong team, you know, see you in 2028, right?
I hope not.
Yeah.
Yeah, no.
We'll talk
It's- yeah,
afterwards.
no, it's-
But
This is important. This is for a separate part of our advocacy with Gurbir, but go ahead.
But I mean, you know, you can save a lot of damage, battle damage, by doing the investigation yourself. I don't expect the government to say, thanks for your report, we accept it all. They're obviously going to pressure test it. But for me, at least, the need to pressure test and the length to which you would pressure test would depend on who the person on the other side of the table is. And that is another example of personnel as policy, right? I mean, I was less focused on the question of like structural independence, like, is this law firm ever done work for this client, than who the person was.
Who the firm is and who the
Yes.
people are.
Yeah.
And the communication back and forth.
But I don't think a public company really has much choice these days. I mean, it's become sort of like, you know, you have to make disclosures, you have to disclose what's going on, you have to find the facts. And so, you know, typically you're not going to, if it's a public company, you're not going to have much of a choice in terms of doing an investigation and actually cooperating in that situation. But there, you know, there's the alternative, which is sometimes they come to you and they've already started investigating, and then you're in kind of a different posture.
Yes,
So,
yeah.
And to quote an Andrew Ceresney speech from years ago, you're really gambling, given our whistleblower program, and to your point, Steve, that, you know, we're not going to find out about it, given how robust that program has become.
yep, particularly now with the Southern District as well. Right?
So I mentioned the Vesco case and the White House call to the SEC and Bill Casey's reaction. The SEC remains fiercely independent of political interference or calls from either the executive or the legislative branch. More likely that those calls come from the Hill than the executive branch. But what's the, I haven't been there for a long time. What's the climate been for you guys? And then we'll get to Gurbir, if he can speak to where it is currently in terms of getting that kind of an outreach or an inquiry or an implicit So-and-so's a constituent of mine, what are you doing?
We got, I would say the Hill, as you said, Bill, is very active. We were complete independence from the White House, as you'd expect. But a lot of inquiry from the Hill. I mean, they were typically unhappy with something that we'd done or didn't do. But lots of, requests for information about investigations. Are you investigating this? Are you investigating that? Sometimes requests, on the policy side, come and educate us about X or Y or Z, insider trading or whatever. And I would say on the opportunities to educate, it wasn't always enforcement. It was sometimes enforcement. We always did that and always took up those opportunities. But I would say on, inquiries about investigations or pressure on investigations or anything like that, we just completely resisted it. I mean, we had a policy of not providing information about any, whether we were or were not investigating a particular issue, and we stayed true to that. I mean, we testified and answered questions and did all that stuff, but I would say some, senators' offices are much more active than others, in trying to, get information and lodge complaints about, whatever we'd done. But we were pretty resistant to it.
Yeah, and I think, our tenure coincided with, at least my perception was a White House that wasn't very interested in the capital markets. And so, there was, and if they had been, there was no way our chair would have ever passed any of that on to us. But we got a lot of, cranky letters from Congress, and we sent back a form letter, and they would just go away. I mean, the point is not that they actually expected us to answer the questions. They just wanted to be on record of having asked them.
Yeah, I mean, from my perspective, there was zero impact. I mean, it has a lot to do with the chair and their perspective. I think Mary Jo was.
I can't imagine Mary Jo would.
It would actually work against you.
Sure, let me tell you about it.
It would actually work against you if you tried to do anything. But and I think probably more important than like us who would get the letters and probably and ignore them would be the staff would be insulated from that kind of stuff, and we would try to make sure that they had there was no impact on the staff, and that they didn't even weren't even aware of that. And I think probably that's true for the most part.
Yeah, I mean, I think it's exactly the same. The one area that I think about a lot is the crypto space, and that's an area where when you think about some of the things that you were talking about earlier, Bill, the criticism after the commission started using existing tools to target foreign payments. I'm sure there was an onslaught of criticism back then that you've exceeded your authority, that this is regulation by enforcement. You don't have the authority to do these things. Some of that probably came from the Hill. Some of that came from people, other commissioners perhaps. And it's very similar to today. And I think our response when we get that, whether it's a letter from the Hill saying, at one point in March of 22 saying you're exceeding your authority, even looking into this space, that you don't have jurisdiction to look at blockchain companies or cryptocurrencies. And then the same legislators, a year later saying you didn't act quick enough. You didn't look into this, as fast as you should have. And our response to all of this whole regulation by enforcement, the criticism, the major questions criticism is that it's probably the same thing that you said back then, or that Judge Sporkin said back then, is that listen, the securities laws are principles-based, and we use them to address new areas of risk, and that's what we're doing today. It's the same exact response. We're using the same tools to address new areas of emerging risk. We don't need, new legislation here. We're protecting investors by applying these tools, and so there's so many parallels to what you were dealing with then and what we're dealing with today, I think, especially in that space.
Back then, that happened also with any of the initiatives into the municipal securities markets. The city of Philadelphia filed an application in federal court to enjoin the investigation. But you're right, it's the criticism you get from the Hill basically gets mirrored eventually in the papers that you see filed to halt the process. So,
but the headwinds are so much stronger today because you have more organized lobbying, you have more trade associations, you have, I don't think foreign payments, but I don't think foreign payments were really an existential threat to Gulf oil, right? It was an issue that they had to contend with, but the issues today are existential to a lot of these firms. And so the amount of money being thrown at this, and also I think what's different today, maybe this is the environment that we're in today, is how personalized the attacks become on the staff representing the commission in these cases, that individual attorneys have to now deal with threats. They have to deal with people getting their personal phones and calling them and harassing them. I mean, as Attorney General, I dealt with a lot of gun safety issues. I fought a lot of cases to the Supreme Court. The 2A advocates are timid compared to crypto advocates in the tenor of their behavior. Right? It's really something to behold, and it has an impact on staff, on burnout and things of that nature. And so it's similar in ways, but it's also just really amped up in a lot of other ways.
I mean, that phenomenon is qualitatively different from the program of 30 or 40 years ago, that the battles were institutional and there would be people that would be annoyed, but the degree of personal ad hominem attacks on individual staff lawyers, and staff people, you get paid $70,000 a year, you don't
A little bit more time.
I was going to say, Bill, you're dating yourself.
I'm dating myself, you're right, but I wouldn't tell you what I started out with Gene Goldman. The two of us couldn't rent an apartment together if we were so inclined back then. But it is stunning the degree of freedom people feel they have to go after individuals. And I'm not sure that's going to dissipate in the near future. Let me talk a little bit about something that has emerged and is now being tempered a little, and that's the rise of the administrative process and administrative proceedings. Back 30, 40 years ago, there was 15C4, which was an administrative action against companies that filed a false report, 15B to go after broker-dealers or associated persons, and Section 8 of the 33 Act to bring a stop order against the registration statement. Now you have the Remedies Act, penalties, administrative authorities, Dodd-Frank, and all these weapons to go after people administratively while the administrative process is under substantial attack in the courts. And where is that going, and how do you see that now as influencing where the program's going to go and what remedies or what vehicles are going to be used?
Well, I would say that there's only one person on this dais who's had the ability to use the administrative process before you broke it for the rest of us. But, after Lucia, we stopped using
After
it.
Bandemir, really?
Yeah, and we had, I think, except for 102Es, no litigated administrative cases during our tenure. I know you haven't used it.
Actually, there was an administrative proceeding filed just today.
Just a handful where we can't get the relief in district court, but yeah, minimal. Like I haven't seen the courtrooms.
Yeah.
I don't even know where they are in the building.
Yeah, well, you guys just filed the 102E today.
Yeah.
That one
Litigated
filed today.
102E.
That one filed today. Didn't it say it was going to be heard before the commission?
It might have said that. We'll see.
I don't
The
want to
whole
talk
commission.
I'm looking forward to where it's going to be litigated.
another pending matter with this Ceresney client.
Yeah, that's right. Yeah, we're only talking about cases I'm involved in today. Well, I mean, can I defend?
I was joking.
No, I mean, listen.
We all know it was George who broke it.
I love seeing these guys blame each other for stuff that,
We actually don't typically, although apparently today just a little bit. No, I mean, I think, listen, sort of you back up the tape, right? Dodd-Frank gave the commission a lot more authority to bring APs, deciding whether to bring an AP or a district court proceeding. And there was a thought that expanded the kinds of cases you should bring as APs. Now, I think the fact of the matter is that we typically brought those cases against registered entities, whether it be a broker-dealer, registered person, investment advisor. I think there were very few cases that were brought against non-registered entities. So when you look at these cases, like that's really who we're talking about. There also, by the way, are obviously remedies that you can only bring, or cases you can only bring as an administrative proceeding, causing cases or 102E proceedings. And so that's your only venue to bring those cases. So, I think at the time, it was viewed as these due process issues and Seventh Amendment issues and the other issues that have now been come to the fore. I don't think they were viewed as credible at the time, but I think the way that the courts have gone and the Supreme Court has gone, I don't know that anybody could have predicted that at the time, and that's where we are today. So I guess we'll see how it all plays out. The most interesting thing will be, what does the Supreme Court do to not so much to the cases that you could bring in both venues, but what about the cases that could only be brought as an administrative proceeding? And those are the ones where I'm sure you guys are watching closely and trying to figure out what to do there.
That's right.
I mean, it is remarkable how notions that were taken for granted about disgorgement and consequences have become penalties. And it's a, I don't know if that's a function of a perception that the program's too aggressive, the change in the composition of the court, the quality of the advocacy on the other side, but it really has changed the dynamic dramatically for how the program has got to anticipate its effectiveness going forward. Let me turn to cooperation, because we always come in and argue where we have a smidgen of an argument that we've cooperated, we need credit, and the debate turns into what's really cooperation, and then how much credit is real credit. And when you've been on this side of the table as long as I have, your frustration grows because the bar seems to keep going up. And Stephanie, you've only been out now a couple of years. What's your sense? Are folks getting adequate credit for cooperation?
Well, no, but no. I mean, look, I think Steve and I struggle with this. We've all struggled with this. I think it's very, very difficult to convey what you're getting for cooperation, right? It's not like we have sentences. It's not like the SEC has sentencing guidelines, and we know that the penalty should be X, and by virtue of cooperation, it's Y, and we can see what that delta is, and we know what we're getting, right? And we don't know, it's not a prescriptive program, so going in, we don't know what we're getting, right? We're going in on a wing and a prayer, and we're gonna cooperate, and maybe we get something, maybe we don't. I think, we certainly, Steve and I did this, Andrew did it, Gurbir is doing it, tried programmatically to show the industry what you're getting for cooperation, to try to message it in a way that points to specific cases. In a case where there's no penalty, you can see what the cooperation, you can see what the value of the cooperation was. What you can't see, right, are those cases where there's cooperation and there's still a substantial penalty, and maybe it would have been higher if you hadn't, self-reported, hadn't cooperated, hadn't whatever, but we'll never know. And we'll never know what it would have been. And the hardest thing are the cases that aren't brought, right? The SEC does look at things, investigate things, and make decisions not to bring cases, maybe based on evidence, maybe based on cooperation, maybe based on a little bit of both. But there's no process there's no process for making public declarations, nor would people who get cases to go away want that. So there's always a challenge, I think, in messaging cooperation. I think we've seen in the last 2 years, in the last really 6-12 months, we've really seen the SEC bring, I would say, a real number of cases, particularly in the public company space, where you can see the cooperation. And I think, we've seen, with that burst of cases, I think we've seen, a lot of what we try to accomplish as well, right? You go out and you message cooperation, everybody's saying, we don't see what anybody's getting for cooperation. And so you really try to be purposeful about showing cooperation credit in a way that is obvious. All that said, look, I think there's still real challenges. I think for real companies with real lawyers, they are going to cooperate, and they're going to cooperate fully. And the gradations of it may vary. And as Gurbir said, it may The level of cooperation may depend on, be tied to things like how much communication is there? How much are you really sharing? Are you completely open and transparent, or are you sort of mainly open and transparent, right? All those things are going to factor in. But the hardest call, bar none, is whether to self-report something. And that is where, that's where I think the greatest potential cooperation credit exists is when you've self-identified and self-reported. And I think it's the hardest call. And lots of times it's not that hard because it's a big issue that's going to become public. It's an issue that's subject probably to you having a whistleblower in your company. Maybe it's got a criminal component and you're going to have to report it no matter what. But there are a handful of cases in the gray area all the time where I think, where they're not subject to a banking regulator being out there or some other thing. And there's a real hard question about whether you ought to self-report this, because you really think as a policy matter, the SEC shouldn't bring a case, should bring a low penalty case, should walk away. You think if everybody looked at it clear-eyed, it really wouldn't be a violation. All those things. I think that's the hardest one. Right. And that's the hardest thing for the SEC to message how they're going to address those circumstances.
Yeah, I think the best way to do that is some of the things that we've, all of us have done, including Gurbir, which is to have programs where you announce that this is going to be what you get, specifically with specifics. And we had the MCDC initiative, which I think, this goes back to what you started with, Bill, which is, it's kind of, it's obviously modeled after something that Judge Sporkin started with the bribery cases and as you were talking about. And, I think the idea, as you say, you're not going to get a penalty if you report it, or your penalty is going to be much reduced, and this is what it's going to look like. And if you have a matrix that you're offering people, that's the way you get people to self-report, I think. And I think you've done a lot of talking about the off-systems cases, and I think, that's what you're trying to sort of message in those cases.
I think that's right. I don't want to rehash what Steph said, but she laid out all the difficulties perfectly. And I think one thing that we've been trying to be super intentional about over the last 2+ years is laying out the behaviors that resulted in the no penalty or the reduced penalty. We haven't done, or the commission hasn't issued orders where, we've clearly said the penalty would have been X, but because of the cooperation, it was reduced. But I think from the off-channel communication cases, you could see like-sized firms who had received a penalty in a certain range and others who have cooperated in that same investigation and are of a similar size and the types of behaviors that they engaged in. You could see the delta across a number of cases. And I think, between being thoughtful about folks who've come in or trying to get it right, we've adopted springing penalties where there's no penalty. And, if you continue addressing the issue, there won't be a penalty. But if the issue is not addressed and you have monitors in place, then the penalty will be X. And I think that's being thoughtful to recognize the efforts to remediate the bad behaviors or the issues that we've identified during the course of the investigation. And, also laying out there, but for that cooperation, the penalty will be X in the future if it's not remedied.
So, I think we're getting close to a close. I want to, before I say a few final words, anything else from the four of you that you think is worth mentioning?
Yeah, I just want to say that one thing, sort of taking stock of kind of my time at the commission is the Division of Enforcement is really kind of a sort of living organism, right? That is constantly evolving and changing to meet kind of new challenges. And some of those challenges are emerging technologies or asset classes or bad things that happen to you in the Supreme Court or whatever. But one of the things that, I'm very grateful for is, whoever comes into this seat, you kind of have the benefit of all the things that have been done before you and the changes. I think most of us who have the privilege of holding this job, you come in and you want to leave the place in a better position than it was when you got there. And, I think, look, two things. One, Rob, who, tore the division down to its studs and rebuilt it. And a lot of the things that manifest the way the division operates or things that he created, the specialized units
Right.
and the professionalism of the, OMI, et cetera. And Andrew since he had hiring authority, he actually hired some phenomenally great people. And when we got in, we had a very, very, high quality staff. I'm not saying it wasn't before, but we had, particularly in the trial unit, where we had lots of people who had lots of trial experience from other places in government, et cetera. And that was a real benefit to sort of inherit all of that work. And I don't know what we did. I'm sure you did something right when we were there, but so it just I thought it was a real privilege to have the job, but also to have the job and sort of have the benefit of what had come before. And if my memory was longer, I'm sure I could say nicer things about older people too.
Yeah, let me just add to that, just to, kind of as much as things change and stay the same. So one of the things about the division that's amazing is the expertise that is sort of resident there, and that really started, I think, with Judge Sporkin and his era. I mean, and the other thing is, as things developing that expertise. So a financial crisis comes, and you need to learn all about CDOs and the like, and being able to do that, having a group of over 100 accountants, like that was, that's a concept that data and the use of data, all of those things kind of, our expertise there that has grown with the SEC really sort of, I think, starts with the era of Judge Sporkin. But the other thing is the change. Like, Steve mentioned trial unit and the trial attorneys that we hired and the expansion of that space. Like, I don't be interested if whether in Judge Sporkin's era there was a lot of trials. I highly doubt that is the case. And I think particularly jury trials and like, I mean, when, we had a year where we had 20 jury trials, and now I'm sure, you guys have similar numbers. And it's, it's just the expansion of that. And also the expansion of the division as a whole. Like, I mean, I don't know how many enforcement attorneys were there when
At the peak, I think, when Stanley left, there were 220 or 240 people in Washington enforcement. That went down in the first 2 years of the new administration to about 190, and then went back up with the insider trading scandals that John Stirk and Gary Lynch basically spearheaded coming out of the M&A era in the 80s. And that's when the budget went up, the staff numbers went up, and the size of the agency went up. But on the trial issues, you are correct. I think the evolution of the number of trials was somewhat proportionate to penalty authority, the need or the pressure for the agency to be more aggressive, and frankly, the expansion of the markets. If you look at not just the new products, crypto, I mean, 10 years ago, no one knew what the word was. But if you look at the mandate, the challenge now, that has evolved so dramatically in 30 or 40 years that it has dictated exactly what you said. Yeah. You've got to evolve and change, and the program changes because you can't keep up with the markets if you don't.
So I just had one final thought to share, and it's sort of building off something I think Gene said and you said earlier in your remarks, Bill, about doing the work the right way and the message that Judge Sporkin would impart to people in the division. And I think a lot of us appreciate this, having come from the criminal world, where nothing that we ever did was about numbers. It shouldn't be about numbers. And when I was a county prosecutor, I would relay this message to the assistant prosecutors who worked for me. When I was the attorney general, I would relay this to all the prosecutors who worked for me and worked throughout the state, that this is not a numbers game. This is not about the number of people you convict. This is not about the number of indictments you get. This is not about the number of arrests you make. It's about doing the right thing in each and every one of these cases. The proudest moment might be the day an assistant prosecutor or a deputy attorney general comes in and says, well, we indicted this case, but we don't have the goods. There was something wrong in the investigation. We need to go dismiss. And that's okay. I think the challenge here is we try to send this message, but we're caught up in this world where we're measured by the numbers, where whether it's people in politics on the Hill, that if your numbers are not at a certain point, you're not doing the work, which is not the case, because we do so many investigations, so many initiatives where we're looking at wholesale failures in a particular space where you have 20 people on it, and it's not going to result in a recommendation, but it's great work. And so when you live in this sort of numbers space where people measure your success by upticks in the numbers, downticks in the numbers, it's not the right space for us to be in. So one of the first things that I did, I think the annual reports are great, but I wanted to draw an emphasis away from these annual reports that they shouldn't be glossy materials celebrating, we did this, we did that. We just did a very simple press release. And I'm sure, people don't like that. But it was deliberately to draw the attention away from being in this numbers sort of space and trying to make sure that we're doing the right thing in our cases and giving out awards internally for people who do great investigations that don't result in recommendations to make sure that that work is recognized in the same manner as the case that brings in a $100 million penalty or results in 20 recommendations. So I think all of us have dealt with this challenge, but it's something, I think it was in your remarks that you were talking about sort of the ethos that Judge Sporkin was trying to build in the division. And it's something that, we very much message out, and I think, it's a challenge. It really is.
So first I want to say to Gurbir and to Andrew and Steve, who traveled here from New York to do this, I'm really grateful that you took the time to come here, and Stephanie to sit on the panel and do this, Rob to show up. It gives you, all of us, I think, a sense of the quality of people and the quality of thought and judgment that if you don't have it when you get there, you get it after a little while. And the division and the agency have been extraordinarily lucky to have people like this sit in the chair that Stanley Sporkin once sat in. He is very important to me personally. He was a friend. He was an enormously significant influence in my professional career. He married me. And this event, we hope to continue every year in his honor, because I do believe that when you talk about the SEC, you talk about the history, there are very few people, and God knows there are a lot of lions of the bar who went through that agency that we all still know. But he was special, and I can't tell you how appreciative I am that everybody showed up and that the four of you came to sit on the panel. So with that, let's all go have a drink.